You don't have to be a billionaire to need a will. Simply put, dying without one can trigger a series of legal calamities, starting with leaving your important financial holdings up to a judge in probate court to decide who gets what. But a will only go so far. While it enables you to name a guardian or executor, a so-called living trust actually is the legal document tying transfer of your property and assets to what your will generally lays out in terms of your general intentions. Fortunately, today we have Aaron Burton, an experienced estate planning attorney at Robinson, Waters, and Doricio in Denver, Colorado. Aaron is part of IFA's National Referral Network of Estate Planning Attorneys, which you can find on ifa.com. Hi, Aaron. Thanks for taking time to discuss this issue of who needs a will and a living trust.
Hi, thanks for having me.
You betcha. Let's start by going over the basics. What is a will and what is a living trust? And most importantly, why do people need these legal documents?
Yeah, great question. So when a person dies, there's a legal process to appoint somebody as the executor of the estate or personal representative of the estate in order to transfer assets.
Mhm.
And that is, in essence, what probate is. A will it does basically two things. It names your personal representative, and two, it directs where your assets go on your death.
Okay.
Probate, in most cases, is handled through a court, which includes court filing fees. Typically, you need to pay a lawyer to prepare the court documents, and this can increase the cost of administration, and it can also delay the time that the assets ultimately arrive at their intended destination.
Okay. And the will just simply directs. And I know a lot of people think they can just put beneficiaries on their financial brokerage accounts, IRA accounts, or whatever, and that will take care of it.
That's right. So probate is limited to assets that are owned by an individual at their death and which do not have a beneficiary designation or which are not jointly titled. And so with a financial account, you can name a designated beneficiary, and that asset will pass directly to the beneficiary outside of probate, which is a much more efficient manner of transferring assets. However, it's not always advisable to name an individual. For example, if you have a minor beneficiary, that minor does not have the legal capacity to enter into contracts to sell the property or to manage the property. And that's where a trust is usually preferred. A trust names a trustee as the person who is authorized to handle those assets, and they have to do so for the benefit of the beneficiary.
And also, if you just name somebody as beneficiary to your IRA or to your brokerage account, that beneficiary gets the step-up basis in tax treatment. But if you need to parcel it out to other relatives, they won't get it, correct?
That's right. So assets that pass on death receive a stepped-up basis.
And what is step-up basis here? Let's
Great question. So a stepped-up basis is when property receives a new tax basis on death. And basis is basically the cost that you acquired the asset. And so, for example, if I acquired Apple shares at, say, $100 a share, and then I die when it's worth $200 per share, if I sold those Apple shares during my life, there's $100 per share of taxable gain. But if I pass those shares to my beneficiaries on death, the beneficiaries receive a stepped up basis from my acquired cost, $100 a share, to the fair market value on the date of death, $200 a share, which means the beneficiaries can sell those assets basically for income tax without any income tax.
So for somebody who owns a portfolio of index funds, like we would advise, who has been investing for years and years and years, that can be worth a lot of money tax in terms of tax savings, correct, over the years.
Yes, the stepped up basis is a very valuable tax planning tool that estate planners like myself utilize to pass assets as efficiently as possible with as little cost as possible.
Okay. So basically, a trust carries out what a will kind of basically lays out. Would that be kind of a correct way to look at it?
Yeah, so the difference between a will and a trust is that a will governs probate assets. Those are assets that are titled in your individual name on death.
Okay.
A trust, on the other hand, is a non-probate tool that can transfer assets outside of probate. And as I mentioned earlier, probate tends to incur a lot of cost, both in terms of time and money. And so a trust is a much more efficient way of transferring assets on death. And it's also ideal for when you have minor children who, like I mentioned earlier, can't sell property or can't manage it. It's ideal for beneficiaries with a drug, alcohol, or gambling problem, where you don't want somebody with those types of issues to receive a windfall. Instead, a trust has a trustee hold that property for the benefit of the beneficiary, and they can make small distributions over time to help protect the beneficiary from going to Las Vegas and putting it all on black, for example.
And it also, again, executes the intent of the will in not only more specific terms and more timely terms, but also you get better tax step-ups and advantages, you wrapping everything into a trust.
Yeah, trusts are incredibly flexible. There are an infinite variety of trusts out there that can be tailored to your individual needs. Wills are a little bit less flexible because wills generally just transfer property outright. It says, I give $100,000 to my niece, and that niece then has $100,000 that she could take to Vegas or use in some other manner you may not want. A trust instead gives that $100,000 to the trustee, who then can supervise the use of those funds.
Okay, well, Aaron, thank you very much for your time today.
Thank you very much for having me.